Hi, this is David for 10 on Tactics, brought to you by tacticsandtrials.com. Today we will review the opinion in Barnes v. Felix, which was recently decided by the U.S. Supreme Court. We will be comparing the Fifth Circuit's moment of threat doctrine and the Supreme Court's totality of the circumstances standard, as articulated in the preeminent case on use of force, Graham v. Connor. The U.S. Supreme Court's decision in Barnes v. Felix, 605 U.S., marks a significant development in Fourth Amendment jurisprudence concerning police use of force. The court unanimously rejected the Fifth Circuit's moment of threat doctrine, emphasizing the necessity of evaluating the reasonableness of an officer's use of deadly force based on the totality of the circumstances. This analysis contrasts the approaches of the Fifth Circuit and the Supreme Court, highlighting the implications for excessive force claims under 42 U.S.C. paragraph 1983. As stated succinctly by Associate Justice Kagan, the question presented to us was one of timing alone, whether to look only at the encounter's final 2 seconds, or also to consider earlier events serving to put those seconds in context. With that matter resolved, we return everything else to the courts below. It is for them now to consider the reasonableness of the shooting using the lengthier time frame we have prescribed. On April 28, 2016, Officer Roberto Felix Jr. of the Harris County Constable's Office initiated a traffic stop of Ashtian Barnes for outstanding toll violations that were associated with the license plates on the car. The stop occurred on a very busy state highway in Texas. During the encounter, Barnes failed to produce identification when asked to produce a license. In addition, he was denying ownership of the vehicle and claimed he was just using the car. He stated that he had paperwork for the car, but it was in the trunk. After smelling a strong scent of burnt marijuana, the officer asked Barnes to get out of the car. The officer opened the car door to assist Barnes out of the car, to which Barnes quickly placed the car in gear and accelerated with the officer clinging onto the side of the car on the busy highway. The officer, who was in fear of being hurt as the car began to accelerate, ordered Barnes to stop. He continued to accelerate and then was shot twice by the officer. Barnes died at the scene. On August 31, 2016, a 12-person grand jury declined to bring charges against Felix in the death of Barnes. Ashtian Barnes filed a 42 U.S.C. Parfa 1983 lawsuit on behalf of the estate in federal district court, which granted Constable Felix qualified immunity. The Fifth Circuit upheld the lower court under the prevailing circuit case law that the moment of threat determines the reasonableness of an officer's use of force. The issues of Felix placing himself in danger by stepping onto Barnes's car as it pulled away, or the fact that the initial reasons for the stop was for toll violations, have no impact under a moment of threat analysis. The 1st, 3rd, 6th, 7th, 9th, 10th, 11th, and D.C. Circuit Courts of Appeal accept and apply the totality doctrine as articulated in Graham v. Connor. The 2nd, 4th, 5th, and 8th Circuits instead apply the moment of threat doctrine. The moment of threat doctrine evaluates Fourth Amendment violations only within the context of the narrow window when the officer's safety is allegedly threatened, excluding the events that precede it. As Texas is within the Fifth Circuit, the District Court and Fifth Circuit rejected Barnes's Fourth Amendment claims under the moment of threat doctrine, which limited the court's inquiry to the short time frame from when the car began moving with Felix in its door sill to the shooting. The Fifth Circuit, adhering to its precedent, applied the moment of threat doctrine, which confines the reasonableness analysis to the precise moment an officer perceives a threat. Under this framework, the court assessed the situation solely at the instant Felix fired his weapon, disregarding the events leading up to that moment. The Supreme Court's unanimous opinion rejected the moment of threat doctrine as improperly narrowing the requisite Fourth Amendment analysis. The court emphasized that evaluating the reasonableness of an officer's use of deadly force requires considering all relevant circumstances, including facts and events leading up to the climactic moment. The court stated, "To assess whether an officer acted reasonably in using force, a court must consider all the relevant circumstances, including facts and events leading up to the climactic moment." The Supreme Court's decision in Barnes v. Felix resolves a circuit split by adopting the totality of the circumstances approach over the moment of threat doctrine. This shift has significant implications for the adjudication of excessive force claims under paragraph 1983. However, the court's ruling does not address whether an officer's own conduct in possibly creating a dangerous situation can impact the reasonableness of their use of force. In this case, the officer implemented tactics that imperiled his life in order to stop a person he believed had committed a crime. This issue remains open for future litigation and lower courts will need to determine how to incorporate such considerations into the reasonableness analysis. Barnes v. Felix reaffirms the necessity of evaluating police use of force claims based on the totality of circumstances. By rejecting the narrow moment of threat doctrine, the Supreme Court has ensured a more comprehensive and context-sensitive approach to assessing excessive force allegations. This decision underscores the court's commitment to upholding constitutional protections for individuals involved in any police encounter. This decision is a must-read because the concurring opinion, written by Associate Justice Brett Kavanaugh, does an outstanding job of reviewing all of the dangers an officer confronts on a car stop and cites some of the more high-profile car stops in law enforcement history. Thanks for joining me. I'm David Demerjian with 10 on Tactics. For more updates on use of force law and civil rights litigation, visit tacticsandtrials.com.